Hello, my name is Joshua Folkard and I'm a barrister at 20 Essex in London. I'm sorry that I can't attend New York Arbitration Week in person, but I'm delighted to record this vignette on the recent United Kingdom Supreme Court decision in Kabab-Ji and Kout Food Group. I'd like to call this vignette a tale of two choice of law rules. Now, I'm conscious that a Dickens novel of a similar name ends badly for the barrister who's guillotined at the end, but I hope that this vignette ends differently. In keeping with the spirit of this conference, who is in charge? For reasons I'll explain, my conclusion in this area is nobody. The facts of Kabab-Ji and Kout Food Group, which had UK neutral citation 2021 UKSC 48, were as follows. A party called Kout Food Group alleged that it was not a party to the relevant arbitration agreement. A majority of the arbitrators held that KFG had been or become a party to the arbitration agreement and made an award against it. KFG brought proceedings to annul the award in France on the basis that it was not a party to the arbitration agreement, and the Paris Court of Appeal, which was the level the case had reached by the time parallel proceedings reached the UK Supreme Court, held that the governing law of the arbitration agreement was French law as the law of the seat, and that under French law, KFG was a party to the arbitration agreement. There was therefore no annulment of the award in France. Meanwhile, Kabab-Ji sought to enforce the award in England. The United Kingdom Supreme Court held that the governing law of the arbitration agreement was English law, and that under English law, KFG did not become a party to the arbitration agreement. The award was therefore not enforced, and in fact, despite the finding of the Paris Court of Appeal, the UK Supreme Court granted reverse summary judgment against enforcement, largely because of a no oral modification clause. The Supreme Court in Kabab-Ji confirmed its previous decision in Enker and Chubb that the governing law of an arbitration agreement, with the exception of express provision, would be the governing law of the underlying contract and not the law of the seat. This saga was finally brought to a conclusion on the 28th of September this year by the French Cour de Cassation, who held, notwithstanding the UK Supreme Court decision, to the French law of the seat approach. We therefore had two of the highest European courts dealing with the same award and the same facts, but coming to opposite conclusions on enforceability because of their choice of law rules. The UK Supreme Court did emphasise that the relevant section of the English Arbitration Act 1996, which was section 103(2)b, should have the same meaning as Article 51A of the New York Convention, and that, quote, it must be applied by constructing states in a uniform way, paragraphs 31 to 32. But since there was no consistent international practice, the English court went back to its common law choice of law rules as set out in Enker. It's said by some English commentators that Kabab-Ji is a pro-arbitration approach because of the willingness of both the English Court of Appeal and Supreme Court to grant reverse summary judgment. I do question, though, whether it is pro-arbitration to have the highest courts of two states butting up against one another in this way in relation to the same award. And that's why, going back to the theme of this conference, my conclusion is that in this area, nobody is in charge. Thank you very much.